My name is Dhenu Maru, and I immigrated to the US at the age of 10 with my whole family. And so, I from India, when I first came, I really didn't have any idea about the legal processes that my parents went through. But what I did understand was the changes of experience, what I now call the immigrant experience, that almost every immigrant has their own version of this immigrant experience. Immigrant experience, which I realized was a feeling when you first come to a new place and you feel totally lost, and you don't really feel too empowered, you don't feel very powerful in that new place. The law is, something which is like when you learn a new game, you really have to first learn the rules of the game. And only by learning the rules well can you ever become a master. I wanted to be a master at understanding this new country that I was faced with. And so the law gave me access to the rules that the country follows and the rules of the game. And I wanted to help other people go through this whole process and understand the rules that apply, both to them and to their families and people they care about. Yeah, so what I'm referring to when I say marriage-based adjustment of status is that when there's a US citizen who wants to marry somebody who has entered the US on some sort of a visa. Now, it can be a visitor visa, it can be a work visa, it can be a student visa. The type of visa, as long as it's a form of visa that requires screening to enter, is any type except C and D visas, which are crewmen's visas, are available. They have the possibility of applying for adjustment if they marry a US citizen. In most cases, with some exceptions, depending on the details. So that's what we mean when we say marriage-based adjustment. That's a very, very good question, because I think one of the biggest nuances in applying for any kind of adjustment of status or applying for a green card when you are in the US, from the US, is the type of visa you entered on carries with it an intention requirement. And the intention requirement of some visas, like the visitor visa and the student visa, the intention requirements are that they have a non-immigrant intent, the intention of returning to their home country. And a marriage-based adjustment is an application for a green card, so it requires the opposite intention, the intention of living in the US permanently. The two are not in line with each other, they contradict each other. If the action is taken too soon after their most recent entry, or the most recent application for admission of some kind of a non-immigrant intent visa, then it becomes a problem. Specifically, if somebody enters the US, say, on a visitor visa or student visa, those are the most common types. They enter the US on one of those visas, and then within the 90-day period, they marry a US citizen and they apply for a green card adjustment of status based on that. Then that's too soon. That casts some doubt on whether at the time of entry they really did have non-immigrant intent or not. So our biggest recommendation is that people wait at least 90 days after their most recent entry to apply for some kind of green card if the entry was with a non-immigrant visa. Yeah, so the documents required are, there's so many documents that are required, but the basic categories, there's going to be birth certificates required from, when we talk about petitioner, the petitioner is the US citizen, the beneficiary is the person who is seeking the green card. So the beneficiary is required to have the birth certificate, marriage certificate, divorce decrees of any past marriages, 2 photographs, passport size photographs, any proof of legal entry. Okay, and the petitioner is required to have their proof of US citizenship. Sometimes it's a birth certificate, sometimes it's a naturalization certificate, or sometimes it's a US passport. They should also have 3 years of tax returns. Only one of those years is submitted, but 3 years information is required. So most recent tax returns, W-2s, pay stubs to show that they're currently employed, because they're also sponsoring financially too. So that's required from the US citizen, and marriage certificate, of course, same, divorce certificate of any prior marriages. There's also a filing fee. Right now the filing fee is $535 for an I-130 and $1225 for an adjustment of status I-485. So those 2 filing fees are required as well. Also, the petitioner should have 2 passport size pictures too. So those are a number of documents, and specifically when we meet with a client, we come up with a tailored list of documents for them. And they should also have some proof of that their marriage or their relationship is genuine. So attorney fees are really based on, each case, and how we charge our fees is that we charge flat fees for each case. So when we meet with the client, we always want to try and talk with both petitioner and the beneficiary in each case, because it's really important that both of them are screened for any potential issues that come up in the case. So after we screen them, we figure out that, what are some of the legal issues that will come up or not, and then based on that we come up with a flat fee. That fee actually covers from the beginning of the case all the way up until the decision of the case, and that's something that we discuss with each client at their initial consultation. If they're a student and they're not making too much money, then they still have to provide all of the same information that every petitioner has to file, but then they also need with them a joint sponsor. Joint sponsor is someone who is also going to have to be a citizen or a resident. So one of the documents that we apply for is called the EAD, or the Employment Authorization Document, or sometimes known as the work permit. And we apply for it along with the green card application, the adjustment of status application, but that is actually received within 5 to 6 months after applying. Even before the green card is issued, people do receive that, and that will be something that allows them to work. But if they have another status, like if they have H1 or something, that status can be maintained, and this application does not prevent them from working on any other status. Yeah, it's beneficial to maintain that status if possible. If it's not possible, the good thing is that the adjustment of status, once filed, it protects or it provides some form of status, which I refer to as a pending green card status. It basically provides some form of temporary status while this application is pending. So if somebody has a hard time maintaining their status, or they cannot maintain their status, they're allowed to live in the US while this application is pending, but they're not allowed to work without the employment authorization document. Many of our clients, because of work reasons and because in today's date, flying and travel and transportation is much more easy, end up for at least a period of time not being able to live together. So while it's ideal that they are living together when they're applying, it's not a requirement. What is requirement is that they have the intention of being married, of having this communication, and they're connected with each other. Traveling internationally is risky if the process is pending and they have not received what is known as the advanced parole, and that is also something we apply for along with the EAD, which I mentioned. that is also issued around 6 months after applying. So once you have that, then that it can provide an option for you to return to the US with an application that's pending. Remember when I told you about the intention requirement, F1 and B1, B2 or visitor visa? Well, that's the reason that traveling is risky, because if you leave the country while you are pending an adjustment and you re-enter on another one of those non-immigrant intent visa, you're again contradicting yourself, risking also abandoning your adjustment of status application. So definitely one of the biggest things that we ask that clients do when they come to our initial consultation is they discuss any anticipated travel, because that will affect whether or not adjustment of status is a good idea for them. A lot of our clients actually ask us about how the interview is conducted. So there's definitely an interview. Interview is typically, when it's a first interview, it's done together. So both husband and wife are in the same room with the officer, and they're kind of sitting across the table from the officer, having a discussion about their application, about any changes to their application, and making sure the interviewing officer is making sure that they perceive that the relationship between the husband and wife is in good faith. Yes, the interview is so important because it's the final step, and a lot of times you can have everything done perfectly, but then if you're not prepared well for the interview, that can delay your case by a lot of time. And so before every interview, we would love to provide an interview preparation meeting. Sometimes it's in person if the clients are able to come to our office. Sometimes it's by phone. In both cases, we want to make sure that the clients are fully prepared for their marriage-based interview. Sometimes it is given right away, but it is becoming more and more rare in today's administration for couples, because there's just more checkings that are done. So it's more and more rare for people to be given an answer on that day. Most often people are being told that they will receive something in the mail in a couple of weeks, and they're being told that the officer will need to review the application again. So if somebody is really lucky, then they hear a yes right away. But having the officer review it again shouldn't be a problem for most people, as long as their application and their material is well prepared. Thank you for asking these questions. I think a lot of my clients ask the same kinds of questions. So I hope that I've given them some information, and if not, please definitely call us 312-854-7065. Or visit our website. It's SwagatUSA.com, which is SwagatUSA.com. Thank you.